Oh,
Hey, Mr. Wilkinson. You can hear me?
I can. Can you hear me?
Yeah, yeah.
Great, great. So you the early bird today.
Yep. And yesterday's Thanksgiving, so everybody.
Yeah.
Some people might be busy.
Doing what? I wonder.
Hmm. Stuff in the gut.
Yes, yes. Stuffing is correct. Well, we'll give them a few moments to get it
Okay,
together.
yeah, that's fine.
I guess if you want to make a cup of coffee or something, you can do that.
Yeah.
Did you have a chance to do the self-assessment questions?
No, I did not.
Understandable. Looking at them, they don't invite you to come and do them. But it's okay. We're gonna go over them anyway. Hopefully,
Okay.
some others have had an opportunity so that we can at least go over them really quickly and then get into special assets.
Okay.
Good evening.
Hello, Anishka. How are you?
I'm okay, and you?
Wonderful. Just fine. Just
Good
fine.
evening.
Evening,
Uh,
Anish.
Nisha sounds so happy. You sound like you got ham and turkey today.
No,
Oh,
I have time yet.
Yeah, at least you get. I have none.
Why?
I didn't order no food today. Now I see all these places. I want ham, turkey, and stuffing. I want turkey and stuffing. I should say.
so how come you didn't order anything?
I wasn't feeling it. You know how we go. How famous go last minute.
You want me to make cook?
Ah,
What?
So the problem is, Anishka, isn't the curfew time 9 o'clock?
yeah.
So that means by the time we're done, you're gonna have to race to the nearest chicken shack to buy turkey.
I'll go. No, I'll go in the kitchen and fix something. I could eat junk on the weekend.
Ah, well, folks might have some leftovers anyway. Maybe tomorrow.
Yes. Oh, definitely.
Yeah, and it will be tastier than today anyway. So you can go and get some leftover ham and turkey, blah blah blah, and then have a real bowl.
Oh, Mr. Wilkinson, Shadell said to let you know she won't be in class tonight. Not Shadell, Shavane.
Oh,
Eating
Shazam.
ham and turkey.
Yeah, she is caught up with what she's caught up with.
Shavane. Yeah, Shavane. Sorry.
Shavane. Okay.
Yes.
Okay, great. So that just leaves Joanne and oh. Did you guys have a chance to look at the self-assessment questions?
Yes, sir.
Okay, great. Let's see if anybody else will show up in the next 5 minutes. If they don't, we are going to move ahead and they will have to huff and puff their way,
Hmm?
catch up. Okay. So let's give them a few more minutes and then we go forward. Luckily, for what it's worth, Unit 8 is not a very long unit. And so that means, depending on how the time goes and how well we get through that, we might actually finish a little bit earlier tonight, which would be great because it is Thanksgiving and you guys
Oh,
can,
wow.
yeah, so we'll see what happens. And then, of course, don't forget our final session is on Saturday at 9:30.
Mhm.
Sorry? Yeah. And that will be on what is the Saturday topic?
Saturday. What is today's day? Saturday topic is hair shipping.
Is what?
Force
Hair
headship,
shipping and
asset protection.
Okay, asset protection and
We have a two.
Force hair ship.
yes, force, airships, and asset protection. All right.
You ready at your ham and turkey, Mr. Wilkinson?
Not yet. When I'm done with you guys, I am going to find a most comfortable chair and put my feet up somewhere and whatever is there, eat it very slowly.
I know.
You have seafood stuffing too?
Not seafood, just the usual, what is it? Ham, turkey, and chicken.
Okay.
Yeah. And macaroni. And peas and rice.
Mm-mm.
Yeah, totally crazy. I feel, I don't know. I hope I don't let you guys out sooner than I should tonight. Just to get to that. Doggone. Yeah, I heard calling my name as we speak. Okay, Kermit, are you there?
Yes, I'm here.
Okay, wonderful. I see we have 5 people in the queue. Who are those 5 people? Where's the 5th person?
That's recording it.
That's Miguel, I think. BIFS. I think that's Miguel.
Miguel, 1, 2, 3, 4. Okay, that's Miguel. All right, well, let's get started. We have a quorum, so let's go. Let's begin with the self-assessment questions for investments. Let me see how well you guys handle that. All right, turn to page, whatever that page is, 59 in my book. Let me know when you get there.
There.
Okay, so number 1, trustee investments. Number 1, trustees invest trust funds in order to provide and you guys have to give me the answers.
Income for the income beneficiaries or
Yeah,
capital
income.
for the capital beneficiaries?
Absolutely. Hey, that's a good idea.
Sorry, we on unit. We going over unit 7 assessments, right?
We doing
Doing
6
6 and 7.
6 and
Unit
7.
6.
Unit 6 first and then unit 7. So if you don't have these answers or the correct answer, please write them in. So for number 1, it should be income and capital. Number 2, trust instruments often provide what?
Express powers of investment to the
Yeah.
trustees.
To the trustees, yes. Number 3, the primary duty of the trustees in deciding how and whether to invest trust funds is to?
Act for the benefit of the beneficiaries
Yes,
and in the best interest of the trust.
absolutely. All right, so far so good. Number 4, what are the general investment duties of trustees?
A trustee must not, you mean number 1, a trustee must not invest in risky or hazardous investments.
Yeah, no risky investments, yes.
Mhm.
A trustee must have full information about an investment before he makes it.
Yes,
A trustee owes a higher standard of care where it is a professional trustee carrying on the business of providing advice and managing trust funds.
yes, and then?
4, a trustee with the power of investment should undertake periodic reviews of the investments held in trust.
Absolutely, okay.
And
If you had,
5, where the
yes,
purpose of the trust is to provide the financial assistance of the beneficiaries best interest will usually be their best financial interest.
absolutely. So the beneficiaries are always first. Doesn't matter if you agree, doesn't matter if you like them or not. None of that stuff matters. The only thing that matters is what's in their best interest. All right.
Mhm.
So yeah, fantastic. Number 5, under the equitable principle that he who asserts must prove, a trustee wishing to argue that a particular investment falls within an express clause within the trust instrument.
Must prove that it actually does.
Yes. So if your attorneys on your behalf as trustees saying that blah 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 is the case as far as the instrument is concerned, no problem. If that's your assertion, then prove it. If you cannot prove it, then you have no case. Even though you might have a case. The point is, if you can't prove it, then you have no case. So if you know that somebody murdered somebody, but you can't prove it, then as far as the courts are concerned, they did not. Unfortunate, but that's how the courts work. All right. Number 6, under Section 5 of the Trustee Act 1998, what considerations must the trustees have before investing? There are
The
at least
trust
3 of them.
the trustees should consider the following: 1, exercise reasonable care, caution, and skill that an ordinary person would.
Mhm.
2, have regard to the suitability of trust investments in the context of the whole of the trust property with a view to obtaining an overall balance of risk and return reasonably suited to the trust. And 3, have regard to the need for diversification of investment so far as the trustees consider it appropriate to the trust.
Okay. Does anybody have anything else you would like to add?
No, everything is saying.
Okay. Yeah. There's also a little discussion somewhere else as an extension with regards to considering the size of the trust property, economic conditions, and the intentions of the settlor. So those are 3 additional ones that might be considered as well.
That's in the section 5, section 2.
Yes.
Those 3, right? Yeah.
Okay. Number 7, what is the standard of care required under Section 5 of the Trustee Act? What is that standard of care?
Mhm.
Why didn't I answer that one? You mean the standard of care for prudent man of business?
That's it. The prudent
Okay.
investor and the duty of care. Okay. The prudent investor, meaning the prudent man investor, and exercising a duty of care. Okay. Number 8, I don't know who's going to read that, but it sure as hell wouldn't be me. Who's interested in reading that paragraph? Number 8.
But the answer is Trustee Amendment Act 2011.
It is.
Mhm.
That means nobody wants to read that. That's okay. We have reading coming up.
Yes, we have reading coming up, and it's 3 of us tonight. So
Hello.
Absolutely. Absolutely.
hi,
Who said hello? Oh, okay. Number
I
nine.
was trying, no, my internet breaking up.
Okay. Can you hear us, Kermit?
I get you now, yeah.
Okay, great, great. Number nine, nobody's reading that paragraph. What is the
No.
answer?
Selection/appointment, and the
Yeah.
second one is continued supervision.
Yes, selection/appointment and continuous supervision. Okay. Number 10,
Periodic reviews.
yes. Did
And
anybody?
I have 11 and 12 blanks, so I don't know why I didn't answer them. So I let you know that in advance.
I can understand why they answer them because they suck. I don't know who out of those. They don't even seem to relate to what we did.
Because I was trying to figure out what I missed, why I can't answer these. I honestly couldn't figure out why I couldn't.
Because the answers are not in there directly. That's the problem. Like the other ones.
Okay.
The other ones, you could search for them and find them. But these two had an interesting twist to them, and somebody called them 11 and 12 for some reason. So let's just say for question 11, explain how to reduce currency risk. And typically, the only thing that comes closest in the discussion is diversify investment portfolio. In other words, if you diversify the portfolio and currency goes down or up in any particular jurisdiction, the whole portfolio will not be affected because you have currency transactions in different portfolios and different currencies in different countries. Okay, so diversify investment portfolio would be an appropriate answer, and then another answer that is not directly in there either would be to hedge against loss. Okay,
What's that
so
answer
hedge,
again?
Hedge against loss. For
Okay.
example, setting up exchange risk contracts so that you lock the rates in, so that whether they go up or down, you won't lose significantly either way. Okay? That's what I mean by hedging. Okay? And then number 12, describe how to structure a portfolio to meet the needs of different client types. The closest response that I saw in our text that you had to extrapolate was number 1, establish an investment objective and strategy. You may have seen that. Number 2, conduct periodic reviews. And number 3, consider market versus book value to measure trust profits. Consider market versus book value to measure trust profits. Okay. What that means essentially is if you're holding a trust assets or securities or stock or bond or whatever, and you purchase it at book value for $10 a share, if you sell it for some reason at $15 a share, the profit would be what? What would the profit be?
Oh, repeat that for me, please.
If you sold
Mhm,
trust shares, if you bought trust shares at book value for $10
mhm.
and you sold them for $15, what would be the profit?
$5.
$5 per share.
Right.
If you sold them for $7 per share, what would be the profit?
You have lost it.
Yes, you would have a loss. That's what I was hoping you'd say. Okay, so it can go either way. That's the point. Okay, just something for you to think about. All right, so let's go to the trust accounting self-assessment questions. Number 1, Trustee Salvar.
What are we going to use? Wait. Oh, trustees have a general duty to account with regard to the trust assets due to the fiduciary nature of their position.
Correct. Number 2.
Capital beneficiaries, life tenants.
Yes, capital beneficiaries, life tenants. Anybody who is not clear on any of these answers, feel free to say, really, what does that mean again? Like, who's the capital beneficiary again? I see. Joan, are you in?
Oh, Joan is in. Okay.
Hi, Joan, are you there?
Yes, can you hear me?
Yes, we can.
Yes.
Did you get to do the self-assessment question, Joan?
Some of of them.
Some of them. Do you know anybody in this group?
We're going to number 6.
Well, actually, we're done with the investment sides. We're on the trust accounting. Do you know anybody in this group that you can get the answers from?
If I know anyone in this, oh, you mean for the other one?
Yes, for the trust investments.
I'm good with that, except for number 11 as well.
Oh,
That's the same thing we just told them, yes. Yes.
Two?
that's funny. Okay, can somebody help John with 11? What did we say the potential answers were for number 11? Somebody help.
Diversify investment portfolio.
Yes, that's one perspective. What's the other one?
Hedge your risk.
Yeah, hedge your risk. Okay, so those are the two possible answers. No. It's funny, she came on and said the same thing. I'm good with everything except those bloody two. I don't know where those two came from either.
And the last one?
And the last one, what did we say possible answers were? Anyone?
Establish an investment strategy. That was one.
Yeah, establish an investment strategy and objective.
Oh, and objective. I missed that.
Oh, it's general like that. Okay.
Yeah, you had to kind of extrapolate it from the text. It wasn't direct like the others.
Okay.
Okay, number 2.
You would then select investments based on the size of the trust and that type of thing. No?
I think we agreed an answer for an earlier one,
Okay.
but that is an answer that you can use for that one as well. Okay. What else did we say were possible answers? Just that one? Another possible answer would be conducting periodic reviews, Joan.
Okay.
And then another possible answer was consider market value versus book value in terms of measuring profits. Okay.
Market
those-
value versus book value.
Yeah, in terms of measuring profits. So those are some of the key things to consider in terms of maintaining and structuring a portfolio.
Okay.
And then we rolled over to the accounting side. The answer to number 1 was general duty to account. The answer to number 2 was capital, beneficiaries, and life tenants. And now we're on number 3, which should be?
Section
Anyone?
89.
Yes, section 89. Okay. Number 4,
Section 90.
section 90, yes. Number 5,
Overpayment or underpayment.
yes, avoid overpayments or underpayments. Anybody remembers why we need to do that? Make sure we avoid over and underpayments. What happens if you pay too much? What happens if you pay too much to the beneficiaries?
Would that leave like less money in the trust reserve or?
Well, it's kind of, it would mean less money in the trust account for other beneficiaries potentially. But it also means there's a great difficulty sometimes if you overpay people to get the money back. Correct? Especially if they live in another country.
Or if they figure it's eventually coming to them anyway.
Sorry?
Or if they figure it's eventually coming to them anyway.
Well, yeah, but I know what you mean. But in practice, it's not supposed to work like that. You shouldn't get anything coming to you unless it's due. So if you get an overpayment, we don't say in trust accounting and trusteeships that, oh, it's 50,000 over, fine, put it towards next year. We don't do it that way. if there's an overpayment, we ask the beneficiary to return it immediately.
They
Some
usually,
benefici- Some return it, others don't. And so if you have a difficulty getting it back, then you will say to them, if you don't return it, we will subtract that amount from your distribution next year. And so next year they would get less. You follow?
right?
The point is, as you can see, it's a big old headache. That's
It
the point.
is. Sound like,
Yes. Trust me on that one. And if you underpay them, what happens then? If
do you
you
pay them again, or it makes you look incompetent or something?
Well, yeah, if you underpay them, they're gonna say you are incompetent. You didn't send them the right amount. They might complain about you, um, even before the court, say that you're constantly not only late in paying the distributions, but you never pay them the correct amount.
Right.
Or they may get together with other beneficiaries in the dark of night and sneak around and say, maybe we should change this trustee.
Yeah.
Even though it's not a big deal, once people get things going, sometimes it's difficult to stop the machine.
Mhm.
Okay, like the situation with the DPM. Somebody alleged, but he was not a defendant. He was not found guilty of anything. But once people started talking, then the whole thing got so stinky. He decided it's time to get the hell out of Dodge, even though he was not found guilty of anything. But that's how it is. Okay,
You talking about what in the papers now?
absolutely. So it's the same thing like beneficiaries. When people start bad mouthing you, even though it may not be true, it could still ruin your reputation
Right.
and even cost you, in the case of a trustee, to lose the trusteeship
Yeah.
and millions of dollars in trust income. Correct?
Right.
Yeah. All right. So that thing about sticks and stones may break my bones, but words cannot harm me is a lie.
It is.
Unfortunately, words could harm you, even when people are lying, because people like to hear
Honest.
unsavory stuff.
That's your character.
Yes. And especially if it's politics or religion or somebody they hate. They love to hear something come out so that they could smear it. Doesn't have to be true, unfortunately. All right, number 6. There were two possible answers for number 6.
All sums of money received and expended in relation to the administration of the trust and the matter in respect of which such receipts and expenditures take place, inclusive of all sales, purchases, and other transactions, be the assets and liabilities of the trust.
Absolutely. Okay. So if you have any version of that, even though you don't need a version, you can take it straight from your text. Okay? Those are the two conditions. Section 2, number 7 of the Trustee Act requires that accounting records maintain basically four things. Number 1,
Correctly explain all transactions,
yes. Number 2,
financial position of the trust to be determined,
yes. Number 3,
prepare financial statements,
yes. And number 4,
um, have the supporting documentation.
absolutely. The worst thing you can tell a beneficiary if they ask for proof of a transaction is you don't have the documentation. Like, where is it? We can't find it. Why? It's lost. They don't want to hear none of that crap. Even if you may have lost it legitimately, it does not matter. Okay? It's the same as me walking into a gay bar. When I come out, people are going to say, we saw Mr. Wilkinson walk into a gay bar and come out. So therefore, by extension, he must be?
Fruity.
Yes. And I may not be fruity at all. I may have gone in to collect a payment somebody owes me. But I walked into the wrong building. That's what happens. Okay? Same as walking, into a doggone strip joint or some such thing. And when I walk up, people tell my wife, Mrs. Wilkinson, I saw your husband coming out of the strip joint. And I'm like, I went in there because I saw a friend from high school I didn't see for 3 years.
Yay. And Jamsey.
Yeah, Anisha, like, yeah, right. But that's exactly what happens. If you get smeared by the wrong person or anyone, or if you get caught coming out of what people perceive as the inappropriate place, you don't have to be guilty to be found guilty.
Mhm.
And people will pin that on you for the rest of your life. No matter how you deny it, like you went in to collect a payment. I swear, God knows it. On my Grammy's grave. Doesn't matter. Depending on our intention, we will drag people right into hell with it. That's just how it is for some strange reason. All right, number 8. The income of the trust fund may be obtained from
Interest on dividends, rental income, loans, deposits.
okie dokie. Any of those and all of those.
Mhm.
All right, number 9. Number 9,
Capital expenses.
capital expenses. Yes. And then finally, number 10, the principle of the trust, which is a very important concept because a lot of times, especially new trust students, still find themselves confused in the middle or the end of the semester. Like, how do assets get into the trust? What exactly goes in at the beginning? And this is really a question about what goes in at the beginning when a trust is established. So the principle of the trust, which is the amount or assets used to establish the trust for accounting purposes, is comprised of what things?
Original trust property and
Original plus property plus
any interest accrued,
any accrued interest, yes. Number 2,
um, any accumulated income, any addition at the principal,
any additions to principal, okay, or accumulated income from the trustee.
mhm,
Number 3,
insurance proceeds
yeah, where do they come from?
from loss of trust property,
How could that happen in practice, you think?
house
That is
burn,
correct. Yeah, trustee property which has a house on it, it burns down, it's trust property, God forbid it was insured,
yeah,
and therefore the proceeds of the insurance will be paid into the trust fund. God help the trustee if it was not insured.
mhm.
Do you follow? Who do
Yeah.
you think will have to bear the loss if it's not insured?
It should have been insured.
It should have been insured, so who will bear the loss if it's not? The trustee will bear the loss, clearly. Now, if the trustee had it insured, then not a problem. The insurance company will pay out whatever the amount is to the trust fund, which will go into the account for the benefit of beneficiaries. But if the trustee was careless and didn't make sure that the trust assets were protected, which is something that will come up in our discussion later this evening, then the trustee will have to take personal responsibility for the loss and pay it out of his own money.
Oh.
So if the loss is 300,000, they have to pay 300,000. And if they refuse to pay, they will be taken to court. Anything else?
Stock dividends
Yes,
and
stock dividends and
from sale of any trust.
yeah, profits from the sale of any trust property. All right. So those are the areas and items that constitute the principle of the trust. Wherever money comes from any of those categories, they would be added to the original principle that was used or amount of money that was used to set up the trust. Can you set up a trust without cash? Anyone?
I would think so.
Yes, you can.
Property.
Yeah, you can set up a
Properties.
trust with
Balance.
you can set up a trust with any type of asset. Cash, property, building, paintings, artwork, stamp collection, cars, whatever you have. You can set up a trust with any type of asset. All right. So if there are no other questions, then we'll get right into special assets and underlying companies. Um, don't forget, in summary, when we talked about trust investments, remember we said that trustees must make sure that they exercise the prudent man concept for investing trust money, that investments must be handled as if the assets were the trustees' own money, that the trustee must make sure that they are qualified people who are managing the investment projects. And at the end of the day, no matter who messes up, the trustee is liable. Okay, at the end of the day. All right. So that's kind of like along with all the other stuff we looked at in terms of the portfolio, um, the review of the portfolio, checking it out, making sure that the objectives and strategies are matching what's happening with the investment managers and so on. And then on the trust accounting side, we know the trustee's biggest job, along with preservation of the trust fund, as usual, is clearly what to do with income, trust income, and what to do with um, interest or income for the trust and capital for the trust. How to allocate income to income and or capital, and how to allocate capital to the various capital accounts. Remember last time on Saturday, we looked at what constitutes income items. Anybody remember some of the items that constitute income for the trust that would go into the income account? Am I the only one who remembered something? What income would go into the income account of the trust? Let me get you started. Rental receipts and what else? Can you guys hear me?
Yes.
I was
Okay,
trying to remember.
okay, just check. Remember rental receipts. If you go back to trust accounting, under trust income, you will see right at the very beginning almost some of the items that constitute trust income.
Oh,
Dividend, dividend income,
dividends, rental income, loans.
loan, yes, income.
Deposit,
Anything else? What
rent-
else?
rental income,
Rental, yes. Anything else was mentioned?
interest on deposit,
Yeah, interest from of any kind, as long as it's interest income. What kind of capital items go into the capital account? So we know it goes into the income account. What goes into the capital account? Trust accounting and the trust capital. Remember in the second paragraph on page 65, they tell us expenses related to the protection and preservation of the capital into the trust fund are known as capital expenses. And therefore, right on the top of that, trust capital may be distributed to the beneficiaries, blah, blah, blah. And they go on to tell us eventually what income items go into capital and what expense items go offset against capital. All right. So when you do your review of that, make sure you're able to distinguish what income and expense items go into trust income and what and what capital expense and capital income goes into trust capital. Very important. Okay. Remember, in some cases, specific income and expenses go to income, specific capital income and expenses go to capital, and in some cases, the trustee has the discretion to do what? Put some in income and some in capital, depending on the situation. So those are the key things to remember as far as the trust accounting side. If you go on to do more trust studies, you'll see that there's a financial accounting side to trust accounting in terms of how the transactions for the trustee are actually posted. and financial statements are prepared, and how information is actually documented and kept on file for reference purpose and documentary purposes and all that stuff. But for now, the most important thing is understanding the difference between trust income and trust capital, and what goes into trust income and what goes into trust capital. Okay.
Is it that capital is more of an asset as opposed to cash?
As opposed to,
Cash, like property, or capital can also be cash.
capital could also be cash. And of course, when we talk about trust capital, what we're really talking about is those assets that are sitting in the trust that will be held by the trustee for the remainderment. Remember those people?
Yeah.
And so when we talk about trust income or capital income, we're talking about any kind of assets that go into the capital account for the remainderment. So that could be cash, property, securities, artwork, whatever the situation might be. Again,
Difference is just who it's being held for.
exactly. All right. The difference is who it's being held for. So those income coming in that's of a permanent nature will go into capital for the remainderment, and those income transactions that will be recurrent year over year for the life tenant until they die, they will go into the trust income. Okay? So yes, that is an effective way to look at it to help you to distinguish between the two types. Okay? All right. So special assets and underlying companies. Let me just say that special assets for the professional trustee is a little different from the assets we saw under investments and trust accounting. For investments and trust accounting, we saw things like cash and securities and land and buildings and all that kinds of stuff. But under special assets, we're going to see trust assets that are a little different from those generic standard type of assets in the trust. We're going to see assets that constitute paintings, very expensive paintings, like millions and millions of dollars in paintings. Where they're going to be held, where are they stored, how are they protected, how do we keep them from getting stolen? So these kinds of unique types of assets that create challenges for any trustee who is foolish enough to take them on. Special assets are very difficult to manage, unlike the ones we were talking about before. And so any trustee who takes on these special assets that we will see have to have their act together. And clearly, they will be expecting to earn significant returns for taking the risk of messing around with these special assets, as you will see. Underlying companies, on the other hand, create another kind of problem. For example, sometimes we have private company businesses that are doing business, making shoes, selling dope these days. They tell me you can sell marijuana now. So I guess all these kinds of things will be part of companies, whatever the underlying company is. And oftentimes, persons who own, family members who own the company, like in the Bahamas, we have Kelly's and other companies that are owned by family members. And oftentimes, um, persons who have private family companies may want to put those companies into a trust and bring them under the protection of a trustee, so that when the initial founders of the company die, for example, then the trustee will ensure that the proper directors and officers of the company are selected and that the company continues to do business infinitely into the future if possible. That's the whole idea. And this is one of the reasons why we set up trusts, especially we have legacy assets, meaning tons and tons and tons and tons of money, or businesses that are doing well and making money. We set up trusts so that the trustee can continue to ensure that that the company or the assets that they put into the trust will continue to um, grow, and provisions are made for the selected beneficiaries of those companies. So the special assets then and the underlying companies create very unique problems for the trustee. And so we'll see those problems in a moment. Kermit, we're going to start with you. Since you're the first person on my hit list, I see. Let's go to page 69, and we start right at the top with the learning objectives, and then you can go right into the discussion about special assets.
Learning objectives. After completing this unit, students should be able to 1. Define special assets. 2. Understand the fundamentals of special assets and underlying companies. 3. Relate special assets to the administration of a trust. And 4. Apply the law relating to special assets and underlying companies to the administration of trusts.
Okay, let's go. Special assets.
Special assets in a trust are assets which require specialized skills and management and have special features that require more non-traditional markets to purchase, sell, trade, or invest such assets.
Okay.
Because of the specialized skill and management that is required for the preservation, protection, or investment of special assets, professional and personal trustees have particular challenges in administering trusts with such assets. Many special assets are liquid assets and do not have the features of more traditional trust assets such as cash, bonds, shares, and other marketable securities.
Question. What are illiquid assets? Anyone? What are illiquid assets?
Technically, a property could be illiquid asset.
Say it again.
I'm saying property or land could technically be a illiquid asset.
Yeah, property is an example of illiquid assets, no doubt. But by definition, an illiquid asset is an asset that is not easily converted to cash. You understand?
Right.
Okay. A liquid asset would be cash because cash is already cash. Another liquid asset would be a CD, right? If
Right.
you open up a CD for 1 year, your plan is to leave it there for 1 year. But if you have a COVID emergency, that's gone, correct? The point is you could go in and say what?
You want your money?
Yeah, and you want it now. And they could say, but didn't you set up for a year? And you said, yes, but this is a liquid asset. Whatever penalty you have to pay me, take it out, and give me my money now.
Right.
All right. And the bank has no legal position to not give you your money. So a CD is easily converted to cash. You follow? That would be a liquid asset. Property is not liquid, it's illiquid because no matter how bad you need money, property sales do not occur overnight.
Right.
They are not easily converted to cash. You have to find a real estate broker, or God forbid, try and sell it yourself, which is a whole other problem. Possible, but it has other problems attached to it. All right. Sometimes it's better to find a broker, pay them their 10%, and let it rip because they are specialists. They know people, they know who to talk to, they know who to go to, they have connections and all this kind of stuff. So that's what you pay your 10% for because they know how to get the property sold far more quickly than if you did it yourself. But the point is, it is not easily converted. It takes time to find a buyer. Then the buyer has to go to their bank if they don't have cash. And if they have to get a loan, it's going to take more time for the loan to be processed, assuming the loan is approved and the property has to be searched and the whole 9 yards. So if you're looking for cash quickly when trying to sell property, not a good idea. You'd better go and break that $5,000 CD if you have it and do what you have to do, especially if it's a what? An emergency. So that is the difference between liquid cash and illiquid. So what we're saying here, the previous discussions that we've had about cash and buildings and cars and all that stuff. Not buildings, cash and maybe stocks and bonds and all these kinds of things. They can be CDs. They can be converted to cash fairly easily. But these special assets we will discover are so illiquid that it creates a challenge. All right, keep going.
Um, with regards to tangible special assets, a trustee must consider the protection, storage, valuation, and marketability of such assets. Tangible special assets may take the form of artwork, coins, stamp collections, precious stones, jewelry, and certain antiques and artifacts.
So you see, they are very different from what we saw earlier and what you discussed even before these sessions with me. That's why we call them special. All right.
These assets are normally transferred to the trust by the settlor or subsequently donated to the trust. Due to the particular challenges associated with such assets, some institutional and or offshore trustees may refuse to accept such assets into a trust.
Clearly, because they're difficult to manage. All right. Very
The,
difficult.
the protection of tangible special assets requires that they be kept in a secure place, normally a large vault under high security and custody. Most offshore trustees place such assets with a reputable custodian under a custody agreement, which may include certain provisions restricting access to the assets.
Who's the custodian? Anyone? Who is a custodian?
One who's just holding whatever asset in safekeeping.
The trustee?
For example, who might be considered a custodian? Like, where would the trustee go to find a custodian potentially to put certain special assets like expensive paintings?
Do we have custodians over here? Do we have them over here?
Sure, we have tons of custodians. Like,
In
who?
Nassau?
Of course,
As in banks?
of
Bank
course,
custodian.
a bank is a custodian.
Mm-hmm.
Oh, you mean like that? Oh,
Yeah,
Yeah.
exactly like that. I like that. So you know what I mean? That bloody thing. Yeah, they're custodians. What do they have in custody?
Whatever you want. Some people, if
Well, they have the depositors' money, don't they?
Yeah.
Yeah, absolutely.
they
And
also
so since they have our money, that's why we take our money to the bank so that we can have a custodian with a big old vault that people
Mhm.
can run off with. That's why we don't keep our money where? Under the
The
mattress.
mattress.
Yes. Now some people consider their mattress to be their custodian. Even today,
Yep.
some people still put money under the mattress or some weird place that is not in the bank. Not a good, not a good idea unless it's just a couple of bucks. Okay? So a custodian is any particular institution or place that can safeguard your assets, whatever those assets might be. So in the case of special assets, if the trustee is an offshore bank, they're not going to keep the expensive painting in the bloody bank. Why not?
only a little office.
Well, somebody will just steal it, correct?
Right. They have
Or
vaults. They have vaults in them.
no,
Oh, that's why.
no, offshore banks, if they have a vault, it's just for their own private documentation.
Mm.
And even if they have a vault for custodian purposes, they may not necessarily want the expensive artifacts and special assets of their clients to be sitting around an office where so
Yeah.
many of their employees are hanging around. Because sometimes people start spying out combinations, planning to thief stuff, tell people outside where stuff is, and then they break into the roof of the bank and all kinds of nonsense. So it's too risky for the trustee to keep it on site. They have to find very special custodians who will keep these things under major lock and key, big time vaults, major security, bells ringing, doggone security guards, dogs biting, whatever the heck it is, to protect your assets. That's why I notice when we go to the bank and deposit our money, we go home and we sleep, don't we? Don't we?
Yep.
Yeah, we don't worry about it like somebody might break in this house and take the money. That's why we have custodians. All right, keep going, Carmen. Carmen said, oh, that thing. Okay, keep going.
The protection of tangible special assets require that they be kept. I already read it. Sorry. Um, it must be noted that notwithstanding the custody of tangible special assets by a reputable custodian and the specialized terms, the trustees, as legal owners of trust property, are ultimately responsible for protection and preservation of trust property. Depending upon the particular tangible assets, there are special conditions under which the special assets must be stored. Whether the tangible special assets are stamps or artwork, which require a dry, secure place with customized temperatures in order to be properly preserved, or precious stones, metals, and jewelry, which require more restrictive security for, for access. Institutional, personal, and/or offshore trustees must take additional steps to ensure that the assets under the care and custody of a custodian are properly um, filmed, documented, and cataloged in order to maintain accurate records and security of such assets.
Notice they must be not just filmed, properly filmed, not no half-dead phone camera. Why not a phone camera? Anyone?
Bad quality.
You don't have, yeah,
Bad quality, of course. All right. So they need to be properly filmed, which means that they may have to hire what? An expert photographer to capture. Then after they're filmed, they must be documented one by one. And if they have any serial numbers or marks or any special points, they have to be written down and noted for each one. Then they must be fully cataloged, which means numbers and identifiers must be attached to them. Because if something happens, you have to be able to give an account for each and every one. So if beneficiaries decide any particular day that they would like to inspect these assets, you have to take them to the custodian and have them see them. And if they want to count every single thing in custody, you must provide them with your catalog, documented, film package so that they can see every single thing and verify it. And if you fail to do that, you know what beneficiaries do. What do they like to do?
sue.
Yeah, they love to sue. Okay? All right, keep going. Keep going, Carmen.
Trustees will also have to purchase. I recommend. I don't know, basically. The cost of storage is another.
No, you didn't read that.
No. Trustees will also have to purchase insurance to cover these tangible special assets in case of loss, damage, theft, or other unexpected events while they are under the care and custody of the custodian or the trustee, provided that the custodian does not have its own insurance coverage for assets under their care and protection that may be suitable for the trust assets.
In other words, sometimes when you go to a custodian to store special assets, as far as insurance is concerned, it is not optional. It is mandatory to have insurance cover. All right. That's the first thing. Sometimes the trustee might cover the insurance, and other times the custodian might say, dude, we have our own special insurance in case something goes wrong. We have insurance against theft, fire, and all that on the one hand, and we have insurance, liability insurance, in case we have to fight with you, the trustee, who might accuse us through your beneficiaries or otherwise of some wrongdoing. Okay, malpractice in terms of managing these items while they're in our custody. See, custody. It's just like when the police take a suspect into custody, they have to be careful how they treat the suspect. Because if the suspect shows up in court with any bruises, then all of a sudden, everybody's attention turns from the bloody potential murderer, wife beater, or whatever, to the police who slapped the hell out of the guy in custody in order to get what? A confession. Okay? And as you know, while suspects are in custody, you cannot physically abuse them to get information, even though sometimes that's the only way you're going to get it. Because people's first inclination, even if they're guilty, is to always lie. It wasn't me. I swear on my mother's grave, my Grammy's grave, God knows it. And oftentimes, it is exactly them at the end of the day. And you think, can people really lie to that extent? The answer is yes, they can and they do all the time. So, this custody thing, um, by the way, do you know why there's such a big stink when the police take a suspect into custody? The reason for that is when the suspect goes into custody, then the police is like a trustee for the suspect, what we call a constructive trustee. In other words, while the suspect is in the police care, they have to take the same kind of care that trustees that we're talking about for special and other assets have to take as well, to an extent, to quote unquote protect the suspect. Do you follow the connection?
Yeah.
Yes, yes.
Okie dokie. I'm just throwing this crap out in case one of you end up in custody. God forbid. Then you'll say, excuse me, don't touch me. I already, Mr. Wilkinson, good thing I took that class. I am a Don. I am in your care. You are the trustee, and if you mess with me and hurt me in any way, I will tell the courts. You bastards. And oftentimes they're the guilty ones who are talking that way. Because not everybody you take in as a suspect is guilty. That's the other reason why they have to be treated a certain way. So the innocent ends up sometimes suffering for the guilty, and the guilty ends up getting treated too well because of the innocent. My. Keep going, Kermit.
The
Just
cost,
broaden your
the
horizon
cost,
a bit.
sorry, the cost of storage is another consideration for the protection of trust assets, particularly such as assets as artwork, antiques, collectible items, jewelry, and precious stones and metals. The location and cost of storage may prove to be very challenging to trustees, particularly those which require special attention and certain conditions to maintain their quality and composition while under the care of the trustee or custodian.
Indeed.
While some items may be stored in bank vaults due to their size and nature, other items such as artwork, antiques, or collectibles may be leased to museums or universities by the trustees so that they may be stored and housed in special locations that are adequately equipped to accommodate such items. The trustees must balance the cost of storage of tangible special assets with the risk of preserving and protecting such items whilst under the administration of the trustees. The valuation of special assets normally require the experts the expertise of a qualified expert or assessor who is able to properly value the assets and determine their true worth. Depending upon the nature and rarity of the special assets, there may be only a few experts who are qualified and able to properly assess and determine the value of certain special assets. This small supply of qualified experts in certain instances drives the cost of valuation of the special assets and presents a significant challenge to the trustees of the trust. However, the valuation of special assets is necessary to purchase adequate insurance for the protection of such assets against loss, damage, or theft.
Thank you very much, Kermit. You said a mouthful already. And so you can see we have custody issues and storage issues, location issues, and even valuation issues. And again, the evaluators for these kinds of special assets do not come a dime a dozen. It's a very small specialized group. And they know that they're a small specialized group. They know who they are, a few of them around the world. And so when you have to call them, they charge you tons and tons of money because they also know that when they are called, they're being called by a major trustee who is managing what? Major trust assets in the gazillions of dollars even. And so when they come in to do the evaluation on the assets for insurance purposes, make no mistake, because of their rarity, they charge you the appropriate fees. Okay? Because we know from economics, the scarcer something is, the more it costs. True or false? Is that true? The scarcer it is, the more it costs.
Yeah,
Yes,
Why does it cost more?
supply and demand.
the rarity.
Yeah, you cannot find it too easily. So if you go to the exchange and there are 10 million apples, you probably can buy apples for what, 5 cents each? But if you go and there are only 100, what do you think they're going to cost?
Much
A
more.
lot of money.
Mhm.
Okay, by all means. All right. There's an old saying that prostitution is the oldest profession in the world, and the reason why I mention that is to give you an interesting insight and valuation and scarcity. If you notice, for example, if you go to a particular country and there are many prostitutes lined up on the street, chances are the cost of prostitute services are going to be significantly low. But if you have to call, like we call a what? High class prostitute, what happens then? What happens to prices?
High class price.
Yeah. Does anybody have any idea what high class prices look like in the real world?
Yeah.
Hmm. Well, if you don't, you can always Google it if you're curious. But it's an interesting example, in terms of valuation. Okay, we may not probably think about it, but if you really think about it, in that case, in any other case, like the apples, um, what I'm really saying is from apples to even prostitution across the board, these principles that we're talking about in terms of the valuation of special assets, they apply. And the reason why they are important is because you have to find the right person to do it and do it at the right price. Bid, whatever the hell that is. All right, Anisha, you're next up.
Yes,
Let it rip.
we stand at another challenge, right?
Yeah.
Yes.
Okay. Another challenge in holding tangible special assets under a trust is the problem of finding a ready and available market to sell such assets when required. Oftentimes, the sales of such assets are done at auctions through reputable auction houses. Additionally, exclusive private collectors and dealers may have to be engaged in the sale and auction of these assets, which may require additional time, costs, and efforts in arranging and finalizing the sale or auction. It is important that particular tangible special assets, such as painting, artifacts, and jewelry, do not remain in the houses or under the care of the settler or his family, due to the high risk of such items being stolen, lost, or damaged and not fully covered by the relevant insurance.
In other words, sometimes when settlers establish, sometimes is my voice doing that?
It's all a bit distorted
My
from your
voice?
connection.
Hmm. Testing 1, 2, 3.
That was clear.
Okay, what the hell was that a minute ago? Yeah. So what happens is sometimes when settlers are settling special assets into a trust, what they want to do is to keep their paintings and their artwork in their homes to look at it every day, even though it's supposed to be under the care of the trustee. So sometimes they'll try and persuade the trustees to keep it in their
Give
home.
second chances.
Yeah, but the trustee will be, any smart trustee will say, hell no. There's too much risk that these things might be stolen or destroyed, and guess who's liable? Not the settlor. Who's going to be liable?
The trustee?
The trustee. Okay? So you got to be careful. And sometimes the settlor may get the trustee to agree to that and steal it himself,
Right.
knowing that the trustee's liable just to get what? Money out of the trustee.
Mhm.
How about that? You'd be surprised to know what folks will be doing. So we have to do things a certain way in order to avoid fraud and theft and damage. Okay? All right, keep going.
Additionally, trustees must consider the application or attraction of certain taxes to such assets such as estate taxes, if the special assets are held in jurisdictions outside of the Bahamas, which levy estate taxes in certain instances, particularly those instances where the assets are under the custody of the settlor and there are legal disputes regarding the ownership of the assets for the purposes of the tax laws in the particular jurisdiction.
All right, so it can become very complex, very complicated. So the trustee has to be very careful when he takes on these kinds of assets. All right, keep going.
Special companies. Trustees may be asked to manage closely held companies that may have been owned and operated by settlers before transferring their full and/or controlling interest to the trustees. These closely held companies may require specialized skill and expertise by the trustees due to their nature and complexity. Since the ultimate liability for these special assets is that of the trustee, many trustees, particularly offshore trustees, may refuse to accept such assets into a trust. The management challenges involved with these companies have caused certain offshore trustees who decide to accept and administer them to include anti-Bartlett clauses in their trust instruments as a form of indemnity for any claims or actions that may be related to the management and operation of closely held companies under the administration of the trust. The case of Bartlett versus Barclays Bank Trust Co. Limited is one which involved the management of a closely held company by the trustees of the trust and explored the particular considerations, responsibilities, duties, and obligations that the trustees have when accepting these assets and trusts under their administration and management. Trustees often elect to serve as directors of such companies to ensure that they have proper governance and management, or appoint certain experts to manage such companies on their behalf. If the trustees manage such companies, there is some consideration for the risk exposure involved in the administration of the trust, and fees are set and adjusted accordingly. Trustees are encouraged to carefully consider whether the type of business of the closely held company, its income and expenses, the business's accounting, the existing management of the company, the provisions of the trust instrument which allow and authorize administration management of such companies, and relevant legal protection or protections, and their qualifications and expertise in managing such companies.
In other words, once the trustee decides to take on a private company, that's what we call the underlying company, a private company that belongs to the settlor. It's almost like the company represents an asset, which the settlor, like any other asset, transfers to the custody of the trustee. Once the trustee takes on that responsibility, now it's the trustee's responsibility to make sure that the day-to-day running of the company is done sufficiently and effectively such that the company continues to go on into, well, into the future. And if there are any activities in the company from a management or other perspective that are not appropriate, the trustee has a responsibility to make whatever changes are necessary so that the company continues to function appropriately. So it's a big job taking on a company that's doing business, not to mention the risk of the type of business that the company's in. Because if the company is in a risky business, moving products that are illegal, moving products that are expensive to move, that have to be insured because of the very type of products that they are, it can create all kinds of problems for the trustee as the person who's responsible for managing that company. That's why we often say, if the trustee doesn't feel that its trust company is capable of managing the company, what it will do, it will hire a manager or a CEO for the company to run the day-to-day affairs on behalf of the trustee. Same way a trustee hires an investment manager to run all of the investment portfolios, so that the trustee does not have to be concerned about the day-to-day issues, which they're obviously, in most cases, not trained or prepared to do. Okay? That's why we have so many professionals who are inside and outside, to which these functions are outsourced and assigned to do these jobs. Lawyers, investment managers, CEOs, business people, all these people benefit from the work of professional trustees, as you can see. Okay, keep going.
Professional trustees also hold shares in companies in accordance with the prudent man of business rule, which required that a professional trustee decide and act as a prudent man of business would in being aware of his investments and ensuring that his investments are made prudently, profitably, and expeditiously.
Okay, thank you, Anisha, for all that already, for taking us out of the special assets and into now the special companies. And so you can see there are two different types of activities, but what do they have in common? Special assets are settled by settlors, and we saw the unique problems connected with them. And then special companies are also settled into the trust by settlors, which create other types of unique problems for trustees. So you can understand, hopefully by now, if only the tip of the iceberg, that managing a trust, a professional trustee's job, is a significant job. If you haven't figured out that these special companies and special assets obviously will not ever be in the hands of an individual trustee for obvious reasons. They don't have the skill or the resources to do it. True or false?
True.
Okay, fantastic. All right, so Anishka, why don't you pick up for us on what the Bartlett's case had to say?
Okay, sorry, where we starting from?
Page 72 to top.
22, J. Cross.
Okay. Oh yeah, this thing. Okay, J. Cross in the Bartlett case stated, the conduct of the defendant trustees is, I think, to be judged by the standard applied in Spite versus Gone, namely that a trustee is only bound to conduct the business of the trust in such a way as an ordinary prudent man would conduct a business of his own. Now, what steps, if any, does a reasonably prudent man who finds himself a majority shareholder in a private company take with regard to the management of the company's affairs? He does not, I think, content himself with such information as to the management of the company's affairs as he is entitled to as shareholder, but ensures that he is represented on the board. He may be prepared to run the business himself as managing director, or at least to become a non-executive director while having the business managed by someone else. Alternatively, he may find someone who will act as his nominee on the board and report to him from time to time as to the company's affairs. In the same way as it seems to me trustees holding a controlling interest or to ensure so far as they can that they have such information as to the progress of the company's affairs as directors would have. If they sit back and allow the company to be run by the minority shareholder and receive no information that shareholders are entitled to, they do so at their risk if things go wrong.
Now, bear in mind that Justice Cross, in a very elaborate and roundabout way, was simply saying this. If a settlor settles a company, a private company, with your trust company, you have a duty as trustee to act as a prudent man. Would act. Now, in the case where shareholdings are concerned, for example, where you're holding the shares of the company, that means that the trustee typically might actually be the majority shareholder and therefore can make all the major decisions or certainly approve them. All right. But what Cross is saying here is this: because of this, you have some options, Mr. Trustee. You may run the company yourself if you think you can to make sure all goes well, or you may sit on the board of that company and have a managing director run the company, or you may have a nominee or somebody sit on the company board on your behalf who is providing you with day-to-day information on the effective running of that company. Just like in the case of investment managers, the trustee, one way or the other, has to make sure that they're getting appropriate and sufficient information about the running of the company. And as long as they're doing that, it's difficult for any beneficiary to say that they're in breach of their trustee responsibilities. However, any trustee, as he says at the end, who is responsible for a company and fails to get appropriate information on how the company is running and whether things are being done appropriately, then the trustee leaves himself open to suit. Because now they're not acting as a prudent man, but instead they're acting negligently in their responsibilities as trustee. Now, I hope all that crap in trying to describe what Cross was trying to say makes it a little clearer to you, but basically that's what all that gobbledygook was about. All right, keep going, Anishka.
Okay. The Bartlett case outlines the prudent man of business rule and requires a professional trustee as shareholder to monitor and intervene in the affairs of a company which the trustee has a shareholding interest, particularly a majority shareholding, as in the case of Bartlett versus Barclays Bank Trust Company Limited.
Anytime you hear Bartlett versus Bartlett case, now you know which case it is. It's the case where the trustee has responsibility for the underlying company and is therefore required to check to make sure that they're up to date on everything that's going on in that company. You follow?
Yep.
Yeah.
So even if you see that in a test, in the Barclay versus Barclay, and you're required to respond to that, you could respond to it in one paragraph that I just told you, but please, that will not get you all the points you need. You will then have to say a little more about what I just said, about what Jay Cross said. You follow? Which is not difficult now that you understand the nature of Barclay versus Barclay. Okay? All right, keep going.
Justice Brading stated that the bank as trustee was bound to act in relation to the shares and to the controlling position which they conferred in the same manner as the prudent man of business. The prudent man of business will act in such manner as is necessary to safeguard his investment. He will do this in two ways. In facts come to his knowledge which tell him that the company's affairs are not being conducted as they should be, or which put him on inquiry, he will take appropriate action. Appropriate action will no doubt consist in the first instance of inquiry of and consultation with the directors, and in the last, but most unlikely resort, the convening of a general meeting to replace one or more directors. What the prudent man of business will not do is to content himself with the receipt of such information on the affairs of the company as a shareholder ordinarily receives at annual general meetings. Since he has the power to do so, he will go further and see that he has sufficient information to enable him to make a reasonable decision from time to time, either to let matters proceed as they are proceeding or intervene in he is dissatisfied.
Thank you very much, Anishka, for that other mouthful. So again, Brightman and Cross are talking about the same thing from two different sides of the fence. In essence, once the trustee gets information about certain things that are happening in the underlying company that's under his care, then he has a duty to do something about it. He cannot look at the information like a typical shareholder and say, oh, well, great, maybe next year will be better. Hell no. If something isn't going right, he has to fix it. If it means firing directors, fire them and get new ones. If things are going along fairly smoothly and they satisfy him with the information they give him, then he says, fine, continue business as usual. But he must be aware, and where appropriate, he must act. That's what both cases are talking about on this page, both Cross and Brightman. Okay. All right. Joan, you're up. Brightman again.
Jay Brightman concluded his judgment by stating, in my judgment, the bank wrongfully and in breach of trust neglected to ensure that it received an adequate flow of information concerning the intentions and activities of the boards of BTL and BTH. It was not proper for the bank to confine itself to the receipt of the annual balance sheet and profit and loss account, detailed annual financial statements and the chairman's report and statement, and to attendance at the annual general meetings and the luncheons that followed, which were the limits of the bank's regular sources of information. Had the bank been in receipt of more frequent information, it would have been able to step in and stop and ought to have stopped Mr. Roberts and the board embarking on the Old Bailey project. That project was imprudent and hazardous and wholly unsuitable for a trust, whether undertaken by the bank direct or through the medium of its wholly owned company. Even without the regular flow of information which the bank ought to have had, it knew enough to put it upon inquiry. There were enough obvious points at which the bank should have intervened and asked questions. Assuming, as I do, that the questions would have been answered truthfully, that the bank would have discovered the gamble upon which Mr. Roberts and his board were about to embark in relation to the Old Bailey site, and it could have and should have stopped the initial move towards disaster, and later on arrested further progress towards disaster. I have indicated in the course of this judgment a number of obvious points at which the bank should have intervened, and it would be repetitive to summarize. I hold that the bank failed in its duty, whether it is judged by the standard of the prudent man of business or of the Skilled Trust Corporation. The bank's breach of duty caused the loss which was suffered by the trustees. If the bank had intervened as it could and should have, that loss would not have been incurred. By loss, I mean the depreciation which took place in the market value of the BT shares by comparison with the value which the shares would have commanded if the loss on the Old Bailey project had not been incurred, and reduction of dividends through loss of income. The bank is liable for the loss so suffered by the trust estate, except to the extent that I shall hereafter indicate.
Stick a pin, Joan, because as a matter of fact, you sounded like the judge in terms of making a ruling, which was good because it kind of left the feeling like, damn, these guys who are trustees ought to have done much more than they did. And as you said, as the judge said, they, as trustees, could not just settle for the annual information that general regular shareholders get, even though they were shareholders holding the shares on behalf of the settlor for that company. Because they were the trustees also, they were no longer regular shareholders, and therefore they were responsible for the day-to-day proper management of that company, which means that according to Cross earlier, if they were sitting on the board, had someone on the board, getting regular information, they would know that that deal for the Old Bailey, whatever the hell it was, was not a good deal for the company. And with the information coming in regularly, but have been able to say to the board of directors, as the majority shareholder in this company, we're not doing that. That is imprudent, makes no sense. It's going to cause great losses for the company. The trustee was not getting regular information, so the board was able to move ahead without the trustee intervening because they were not acting prudently. And as a result of that, the company lost tons of money on the project, lost value in the shares for the company, and therefore the result was a lawsuit wherein the courts ruled against the trustee and said you did not act sufficiently as trustee and shareholder for this company. And therefore, whatever loss or whatever claim is being made, you will be liable to pay. That is a mouthful, but that's what trusteeship is all about. If the police arrest a suspect and beat them half to death, the commissioner of police is responsible because the commissioner of police is the trustee. Even though he may have been home in his bed sleeping when it happened, doesn't matter. He's the head of the heap. And therefore, once that information comes to his attention, he can't say, you know what, these boys are so rude, beat them up some more. Don't bring it to me. Do what you have to do. He can't do that. He has to act on the information. Is it really? They're beating up a suspect. How do they know that that's the correct suspect? Suppose it's the wrong person. You follow? And so, as the trustee of the police department, he's now duty bound to act. And if he doesn't, here or anywhere in the world, he can find himself being sued and liable for negligence. Just as in the case of Barclays and Barclays and the trustee, who did not get enough information on a timely basis to make the right decision. Okay. All right, keep going.
Commercial real estate. Certain special assets may be in the form of commercial real estate. Some commercial real estate may be of a particular nature, such as mining operations, farms, wineries, and other commercial interests which require more special skill and knowledge to operate and manage properly. Trustees often hold these types of assets in underlying companies and hold the shares of such underlying companies which represent their ownership interests. There should be certain provisions in the trust instruments which allow the trustees to repair, upgrade, carry out construction, mortgage, insure, and do certain other things that a typical legal owner would do in relation to his property. The imposition of certain taxes, levies, rates, assessments, and license fees on these commercial and real estate properties, particularly those in foreign jurisdictions, may prove very challenging to offshore trustees in the management and administration of such assets under their care. As with other special assets, the trustees should appoint persons with the relevant expertise to properly manage these commercial interests, particularly those which require more specialized knowledge and skill.
Thank you, sir, very much, Joan, for all of that. And yes, the final major special asset that Joan touched on was the commercial property. The problem with commercial property, sometimes without trustees, we have somebody called a commercial property manager who is a kind of constructive trustee anyway, because if you're a commercial property manager, you're expected to do all those things that Joan just mentioned in terms of maintaining and keeping the property in order. If you don't do those things, then you might be found to be incompetent and guilty of not carrying out your responsibilities. In the case of a trustee, where commercial property is part of the trust assets, the trustee has the same responsibility to take care of the property, insure it, maintain it, clean it, cover it, whatever needs to be done to maintain the property and keep it in good order. If they don't, beneficiaries can sue, and if they can prove it, they can win. Okay? So trustees have to exercise due care before they take on special assets. I think you've gathered that by now. It's a big time headache. It's very lucrative. You can earn a lot of money in trustee fees by managing these special assets, but they can also be a pain in the butt. And if you're not careful, they can cost you significant amounts of money if you're sued for any reason, negligence or otherwise, or breach of trust, and can put a big dent in your balance in your income statement, right? In terms of your legal expenses. All right. So we started with Kermit. So we're going to end with you, Kermit. Why don't you uh, take us home with other special assets and underlying company?
The trustees may have certain speculative and risky investment instruments under their administration, such as derivative options or future contracts. Due to their nature and the use primarily in hedge risk in most investment portfolios, trustees should be very wary to include them in their investment strategies, particularly when they consider the nature of the trust assets and specific needs of beneficiaries of a trust, which may be unsuitable for such assets.
Why do you think, in the case of derivatives and such assets, um, investments, sorry, why do you think the trustee is cautioned to avoid them?
They're more risky, like I
Yeah,
can.
they are major risk investors. As a matter of fact, uh, even in the real world of investments, if you read up on investing activity at all, you'll be told somewhere that if you can't afford to lose money, don't invest in derivatives and any speculative investments. Leave that to the big boys who can afford to lose millions overnight. Because on the other hand, if they get lucky, they earn millions overnight, so to speak. But the trustee cannot play that game because that money is not his. That money is from the trust. And if it gets lost because of risky, remember we saw earlier, the trustees encouraged not to get involved in any risky investments. Investments must be substantive but safe and reasonable, not risky. Risky does not even come into the discussion. That word should not be in near any trustee's mouth ever. Not if he wants to be deemed a trustee who is being prudent. All right, keep going.
It is important that trustees properly review and consider the suitability of certain investment securities when deciding to accept certain assets or invest generally. Their ultimate responsibility is to protect and preserve the assets in the trust and ensure that they act in the best interests of the beneficiaries and the administration of the trust.
As usual.
Underlying companies. Trustees often hold certain trust assets through ownership of shares in underlying companies. In offshore jurisdictions, these companies are normally international business companies, IBCs, which have special features which allow the trustees to minimize their risk, expense, operation, and management.
Let me ask you guys something. Is the Bahamas an offshore company? I mean, a country that has offshore companies?
Yes.
What about BVI?
Yeah,
Cayman?
yeah.
All of these countries in this part of the world that's doing what? Offshore business. What does offshore banking mean? What does that expression mean?
Outside of the mainland,
And who would be considered the mainland?
U.S.,
United.
Yeah, the major countries of the world. Not only the US,
UK,
Canada, China, Europe, Africa, Asia,
Australia.
Australia, and South America, and so on, wherever they have mainland countries. Okay, they are considered mainland countries. Little countries like ours that are hanging out somewhere, we are considered offshore for the purposes of banking and trusteeship. All right, keep going.
To ensure additional governance, management, and oversight of these companies, the trustees often have corporate or individual directors who act on behalf of the trustees as shareholders. As directors, there are certain legal duties, and responsibilities that are owed to the shareholders of the company and to the company generally. It is critical that shareholders of such companies, particularly trustees of trusts, be given information regarding the overall management, governance, and corporate oversight in a timely and professional manner in order for certain important decisions to be made. Special assets are held more conveniently to underlying companies as they allow the ease of control and management by the trustees. In most offshore jurisdictions, such as the Bahamas and British Virgin Islands, IBCs have no capital gains, corporate or other taxes, and and the cost of incorporation and administration is relatively inexpensive when compared to other corporate vehicles. In addition to the to the relative what was the word is?
Relatively,
Inexpensive.
No, in addition to the
relatively,
relatively
yes.
relatively um, low cost of incorporation, exemption from taxes, and ease of operation, IBCs also allow trustees to maintain the level of confidentiality and anonymity that
Mhm.
is required in the operation and administration of offshore trusts.
Absolutely. So I think now hopefully we have a better grasp of first of all what special assets are, what underlying companies are all about, and what and their relationships to trustees and trustee responsibilities. Clearly, the underlying issue is whether there are special assets underlying companies. Um, the trustee must make sure they are acting prudently, that they're taking good care of the assets, that if it's an underlying company, that they're controlling the company. If they're not able to do it themselves, designate somebody to do it, get the information that they need, because at the end of the day, the trustee will be responsible for what happens to the company. Okay? Can't say the managing director messed up. You could say it, but at the end of the day, you are liable as trustee. And so I think between the justices and what everybody had to say, we made it pretty clear that the trustees' responsibilities in these instances are clear. Those trustees who seek to do this well will be successful. Those who seek not to do it well will be hit with significant lawsuits, breach of trust issues, and potentially significant losses in income, okay, that they end up paying out to whomever. All right. Any questions about anything we talked about this evening? Okay, wonderful. Well, when we come on Saturday morning at 9:30, we'll cover our final topic, which has to do with forced airship and what?
Asset protection.
Asset protection and asset protection trusts, which will end our sessions already. It's amazing how quickly time passes. Or please also go ahead and complete the self-assessments for the last two units, and we'll discuss those first on Saturday morning before we get into the final unit. All right. If you have any questions as usual along the way, feel free to send me an email for whatever reason. I'll be happy to respond. If there are no other questions, then you guys have a happy and enjoyable remaining Thanksgiving. Try not to eat yourself silly. And I'll see you guys in a few hours on Saturday morning at 9:30. Okay?
Okay,
Okay.
All right.
bye
Take care.
everyone.
Good night.
Night.
Okay, all right.